Hello to everybody. My name is Frédéric Jenny. I'm a professor of economics at ESSEC Business School, and I'm the chair of the OECD Competition Committee. And I'm very pleased today to have a new edition of the Concurrences podcast series in discussion with Eleanor Fox, who is a well-known professor of antitrust at New York Law School. Today's topic is big tech, what's happening in Europe, what's happening in the US. So let me ask Eleanor the following question. I mean, there's a lot of controversy on both sides of the Atlantic, and I would say in the world in general, but more particularly on both sides of the Atlantic, about whether there is a big tech problem in competition or in competition law. So my questions to you are, do you think that there is indeed a problem? How do you characterize this problem? And what do you think we should do about it?
Well, thank you, Frédéric, and hello, everybody. And wow, that is a huge question. And of course, it is the question facing all of us in the competition field today. So do I think there is a big tech problem? Yes, I do. I think there is a big competition problem that has happened to come up in the form of big tech for certain particular reasons, which I will mention. And what to do, how we should treat the problem in competition law is, of course, another huge problem. And I'll start us out on that. And then I'll reverse the question and ask you, Frédéric, how you regard these big issues. So this is what I think about the big tech problem. The big tech problem is associated with the fact that it's only fairly recently that we have moved into a high-tech world with such ease of communication across the world, as well as delivery of products and services across the world, knowing no national boundaries. And in this area, the companies that will take this space and have huge network effects, both good and bad. Both because on the good side, take Facebook, for example, although maybe it's getting to be the vehicle for people over a certain age, but let me take Facebook as an example. Anyway, you want your friends to be on the same page. You want to communicate really easily with your friends. Or Amazon, a small supplier wants to communicate across the world to what it supplies, and buyers want to buy across the world. And being on the same page can facilitate that transaction enormously, which means that there is the possibility of these markets tipping into monopoly, but maybe not tipping into monopoly, but still having this relatively small space for entrants to enter and expand. And so the negative side of it is that it can create monopoly power, or at least unilateral power. And the not just antitrust or economists, but the social scientists are also documenting huge ills from so much control over people, what they think, as well as what they buy, and so much control over the marketplace of what is sold and what is bought and what we want and what we think we want, and our minds being played with. And privacy and data. The data problem is also part of this very unique problem, because for the first time, given these new technologies, the firms in the field are able to extract huge amounts of data from all of us to sell it at a great profit on the market side. Also, possibly people fear to use it for surveillance on the social political side. So the companies that have entered this space, the platforms, and there are only a few, but the platforms have entered with a vengeance, and they're bigger than, their capitalization is bigger than the GDP of most companies, and they know no borders, so it's a global problem. One of the big problems that has emerged is how to define what is sufficient power, which is always a threshold question if you're looking at the unilateral conduct statute of any jurisdiction. In the United States, the standard is said to be monopoly position. In EU, it is dominant position. The firms might not easily fit the traditional definitions of power. So if we were to become very economically technical and say, can these firms lessen output and raise price? Very difficult to say they can lessen output. They actually want more output. Price, very difficult, especially because the platforms have entered the markets by giving a lot of what they call free services, and they have to recoup some way just to make profits. And they might recoup by another side of the platform, raising many very difficult antitrust questions. So an additional difficult antitrust problem is, the first one being, it might be hard to find monopoly power, and it might be hard to find what our now pretty conservative US courts are calling abuse or anti-competitive practice within that framework. And therefore, we might want to or need to look at new forms of thinking about what is sufficient power for antitrust intervention. And a related huge problem is this. I've been talking so far as if antitrust intervention is all case by case. It takes cases huge numbers of years to get decided. So in the US, we have several cases pending against big tech, and they're almost sure to go up to our Supreme Court. They have to go from a district court to an appellate court to the Supreme Court. It might take 8 years before that case is determined. And the company is saying, I can do this. I made the platform. I can do what I want on my platform. US law gives me huge power to do what I want because it doesn't want to chill my incentives to invent. And that is an argument that has legs in the United States. And that will go up to the Supreme Court. By the time the Supreme Court would hear and adjudicate the case, the market may well have changed. And of course, that's a counter story to saying this power is durable. So I see the problem as huge, all of these technical as well as economic and social problems as huge. And maybe towards the end of it, we can get to what I would suggest to do about it. But US right now is kind of in equipoise with a lot of support on both sides of the coin. One side is to say our Supreme Court law is fine and let's go along the way we are. And the other side, which has been a huge voice lately, very strong rhetoric, is to say these companies need to be reined in. And it's not just these companies, that our antitrust US is too weak. And there is a whole package of proposed legislation that would strengthen our law, our antitrust law. We don't know whether and how much will get passed. So EU, I think I'm going to stop there, Frédéric, because maybe you want to say something on the EU side, and I don't want to take up all the time because we could talk about this for hours. So why don't I turn it over to you to ask, what do you think is the problem? Do you find fault with some of the things I said? And you might want to go into the area of solutions as you like. Thanks.
Well, thank you very much, Eleanor, for this very lively presentation of the issue as it is in the US. One of the things that struck me in your presentation was the fact that you said not only do we have a problem, but we have a problem of creation of unilateral power. Now, as an antitrust enforcer or past enforcer, I would say I don't know if we have a power problem. We may have an abuse of this power problem, but that's a different issue. So there is a concern that large, successful, and profitable tech firms have a lot of market power, as you have said, but it's not the power per se, which is, I mean, at least in my mind, the source of consideration or the source of concern. It is the fact that they could abuse this market power and engage in other anti-competitive mergers that would stifle innovation and competition or anti-competitive practices. Now, the problem is that it could be also the case that they are successful and powerful, not because they resort to anti-competitive practices, but because they provide innovative or quality services, which are highly valued by users and consumers. I'm not saying that this is the case, but it could be the case. At the same time, and that's where the complexity sets in, it could be that the quality of their services is due partly to their large size. And you suggested this when you talked about data. We know that artificial intelligence allows firms with access to large sets of data to better target their services to the needs of their consumers and to deliver better services to them, or at least services that they value more. So competition authorities have to distinguish between those effects. There's power, there's abuse of power, and there's possibly efficiencies or innovations. We don't want to get rid of the innovation. We don't want to limit them. We don't want to get rid of the efficiencies, but we would like to get rid of the possibility of abuse of market power. So to me, what it says is that the proper focus for competition law should not be to say power is bad per se, because I think it is neutral. It can lead to terrible things, but it can lead also to a positive efficiency things. So this is where things get very complicated in the digital sector. And let me explain for 1 second. From the point of view of competition, we do have a problem if innovation is slowed by big tech firms, or if the quality price ratio of the services that they offer is lower than what it could be if there was more competition. But the difficulty is to assess whether this is the case, because the digital world is also a world where we have seen a lot of innovations, okay? So it's very hard to know whether we should have seen more, which did not occur because of anti-competitive practices, or whether we've seen quite a few thanks to the fact that there were powerful firms that were able to develop some of those innovations. Now, why is it difficult to assess whether what the reality is? I think the first reason is that competition between digital ecosystem doesn't work the same way as competition between pipeline firms. And the competition law instruments that we use need to be adapted to the reality of the digital sector, and they are not at this point. We need to adapt a competition law enforcement, which is largely, and you've mentioned this in a previous podcast, been looking at a Stiglerian static price competition point of view by pipeline firms to adapt this instrument to what I see as being a Schumpeterian dynamic competition on innovation between ecosystems. Now, this requires a lot of work. Once we're able to better understand how competition works between ecosystems, and we're working in that direction, of course. Then the next question is the other one that you mentioned: is competition law, is the competition law instrument in itself inadequate to deal with the digital sector, because the digital sector moves faster than we can, in fact, use our instruments? And that is, of course, the issue of whether ex-ante regulation should complement antitrust in trying to deal with those issues. Now, there are ways to combine ex-ante regulation together with antitrust. Certainly the UK, for example, is a good example of this. But I think that the first step is to understand the mechanics of competition and innovation in the digital sector before we go too far. I understand the urgency to intervene, but I also see the ambiguity of not knowing whether those big tech firms are successful because they are good or because they are bad. And I think that's what we have to find out.
So that's very interesting and might require lapse of some time before we say, yes, we do understand. So I want to, first of all, comment on power versus conduct. And then I want to propose that there might be a middle way, taking again some of your thoughts on ex-ante regulation, except that for you it would be waiting. And I want to suggest maybe we know enough on some particular points to not have to wait. So my first response on the power versus power plus conduct is, I think that that's basically true. At least the antitrust and competition laws so far are not attacking the dominant position or the monopoly position, but also require anti-competitive conduct along with it, which is the abuse. In the United States, there actually is a movement that would undercut that or push back against that. And that is the movement, which is called loosely, Break Up Big Tech. You see it all over. It was in our last presidential run up to the president with the campaigns, but also Neo Brandeis School often will have these statements in their position papers: big tech is just too big, it has to be broken up. I'm not on that line myself. Some of the legislation would actually do some separation, for example, of the big gatekeepers from the business on their platform. I myself am not in favor of that. And frankly, I do not think we're going to just take a hammer and break up big tech. However, I do think that we've learned a lot about abuses of these firms. We've also learned a lot about what the firms give us. And you've mentioned a lot of the pro-competitive, pro-consumer things that they do give all the people that the people want. The people might not be happy if a sledgehammer broke up big tech, because they would be losing their friends and their business community that they had wanted. What I think is that there's a handful of practices that are so abusive, and that until we get clearer law, the companies do not agree. There is certainly a big contingent in my country that does not agree with what I am going to say. I think there are some abuses and a handful that can be separated out that should be the subject of rulemaking, which would be very light regulation. And I think our Federal Trade Commission could do it under its rulemaking power, although its power is somewhat in question and Congress might need to reinforce its power. I would like to take a leaf from what the EU has done and what the UK has done in identifying certain practices. And I might even make them narrower. So for example, I give you the example of what Facebook did to Vine. Vine was had a new idea at this time for producing very short videos, that is allowing its users, giving the wherewithal to the users to make very, very short videos that they could send immediately to their friends. Facebook thinks of itself in this space and thought of that as a competitive threat. Vine was on Facebook and expecting to use the usual data flows that were available on Facebook. And as soon as Zuckerberg heard of this, Zuckerberg said to his people, cut off their data. So that was one incident, which I call sabotage on the platform. And there are people who say, yeah, Facebook has to be able to do this because it's part of the freedom of firms to do what they want on the platform they have invented. And indeed, our federal judge in FTC against Facebook so applied the US law and said for exactly that incident, that's okay. It's not a violation of US law, citing Trinco and several other cases along that line of freedom to do what you want when you make the platform. No duty to deal in the United States, except in a very narrow pocket. So I think sabotage on the platform because someone has gotten too good can be identified as that's just abusive, illegal, and anti-competitive. And we shouldn't have to go through the measures of determining, does Facebook have monopoly power? The judge in FTC against Facebook also threw out their first complaint to say, you haven't alleged enough for me to even think that Facebook might have monopoly power. This power problem is a real problem in the United States. So we shouldn't have to parse that question every time. And we should, every time such an incident as Vine comes up, we should know that's wrong. They can't do it. And if it's not a violation of our antitrust laws now, it should be a subject of FTC rulemaking. So sabotage on the platform when you're a big gatekeeper platform is one. Several others, but I'll say this also because it's in a different sort. Interfering with interoperability and data portability. I think rulemaking can be done without destroying any of the good things that platforms give us. Over to you, Fred.
I don't disagree with you, and I do think that maybe, I mean, there may be also middle ground in terms of reversing the burden of proof in some cases when one is dealing with a very powerful firm, just for the reason that there might be, I mean, one might want to be more cautious than in other cases. Now, on the specific examples that you gave, indeed, the question that you raise is the interpretation of US antitrust law so narrow, particularly when it comes to refusal to deal, that it doesn't see that there can be an anti-competitive practice which is going to try to prevent a competitor from growing and from surviving by cutting off. Now, in Europe, that practice would certainly have been considered to be an anti-competitive practice under European case law. The next question is whether it would have taken too much time to figure that out, and whether in the meanwhile, this competitor would have disappeared from the market, and whether in that case, there's a need to have a more expedited procedure. And this is where the question of ex-ante regulation comes in. But as you said, I mean, it has to be very narrowly focused to make sure that we don't prohibit practices which may either promote innovations or promote competition. So I'm not a doctrinaire on this. I just say we have to precisely identify cases where it should be, where one could edict a general rule or follow the CMA approach, which is I have regulatory power, but I'm going to use them in a bespoke way. I'm going to tailor my regulatory powers to each specific case. And I think that this is less threatening than over-the-board regulations. So that might be also a possibility. Thank you very much for this exchange. I mean, we have tried to converge, and I think that we see that there's a need for a middle ground on those issues. So thank you very much, and thank you to all the listeners for having listened to our conversation.
Thank you. My pleasure.